Got some words for you. Challenging, evolving, competitive, stressful. I think it's safe to say that any of these words could be used to describe the legal profession today. But how about blissful? For most of us, that seems like a bit of a stretch, considering that even the most prestigious law firms across the world are facing unprecedented pressure from our clients. They want attractive fees, added value, superior service, not to mention they want you to be tethered to your smartphones and your tablets 24/7. In fact, when I sent out the invitation for this event, I got quite a few cheeky emails from people with some alternative descriptors to Bliss. But by far and away, the best response I got was from my former partner. He agreed that bliss was the perfect word to describe his professional status. He's retired. Deborah Epstein Henry believes that we can and will get to a place where bliss becomes a part of every lawyer's everyday vocabulary, and not just after we set sail for Aruba. In her new book, Finding Bliss, Innovative Legal Models for Happy Clients and Happy Lawyers, Debbie and her co-authors, Susie Scanlon-Rabinowitz and Gary Berger, explore ways to improve the delivery of legal services and the daily lives of lawyers. Finding Bliss encourages readers in the legal industry to be strategic, creative, and courageous as they shape their future with a particular focus on how women and men can affect meaningful change in the workplace structure and policy. My name is Linda Myers, and I have the great pleasure of welcoming everyone to today's event. I'm a corporate partner here at Kirkland & Ellis and a member of our firm-wide management committee. Here at Kirkland, Debbie is one of our favorite collaborators and someone I am so proud to call a true friend. So I am absolutely thrilled to kick off today's discussion focusing on her new book and to introduce our other featured guest, Anne-Marie Slaughter. As most of you know, Debbie is an expert consultant and speaker on the future of the legal profession, new legal models, women's issues, and work-life balance. In addition to co-authoring Finding Bliss, she is the author of Law and Reorder, the #1 best-selling ABA flagship publishing book for 2011. She's also the president of Flex Time Lawyers, a firm that provides consulting, training, and speaking services to law firms, companies, and not-for-profits. She's well known for running the Best Law Firms for Women initiative with Working Mother magazine. Debbie attended Yale and Brooklyn Law School cum laude and is a former practicing litigator. She lives in Philadelphia with her husband and her 3 sons. Interviewing Debbie today is Anne-Marie Slaughter, President and CEO of New America, a public policy institute and idea incubator based in Washington and New York. Anne-Marie served as the Director of Policy Planning for the U.S. Department of State and was the very first woman to hold that position. She's formerly the Dean of Princeton's Woodrow Wilson School of Public and International Affairs at Princeton and the J. Sinclair Armstrong Professor of International, Foreign, and Comparative Law at Harvard Law School. She has written and edited 6 books and frequently contributes to a number of publications, including The Atlantic. I'm sure you remember the 2012 Atlantic article, Why Women Still Can't Have It All, which became the most read article in the history of the magazine and reignited the gender equality debate in the workplace. Anne-Marie lives in Princeton with her husband and her 2 sons. Before we begin today's discussion, I have my usual housekeeping items to remind you of. There are members of the press here today, and so we've asked if they want to report on anything with attribution, they seek permission first. Second, although today's remarks are attributable to individual speakers only and not to any particular organization. And finally, for those who are participating here in New York, we are going to open up the floor to questions probably about 1:30 following the interview. Unfortunately, we can't take questions from the webcast, but we do encourage you to join the conversation on Twitter with the hashtag FindingBlissLawReorder. Our program will wrap at 2 o'clock Eastern today. Now, please join me in welcoming Anne-Marie and Debbie.
Thank you. Thank you. So we're going to have a wonderful discussion. It's particularly nice for me to be here because I cited Debbie's first book, Law and Reorder, in that Atlantic article before she and I actually knew each other. I had just found the book, thought it was terrific. As a former law professor, knew that law did need a certain amount of reorder. And since then, we've We've had a number of occasions to be together. Most recently, she interviewed me. So now I get to interview her. But before I ask her the first question, I'm going to let her say a few words.
Sure. So let me start with you, Anne Marie. I'm so grateful, and I remember that day, the summer of 2012, when that article went viral, and getting this flood of emails about this article, and then finding my name in it, and I was so touched, and so really been honored to have the opportunity to collaborate with you, and most generously that you wrote the foreword on this new book. And so I can't thank you enough for your generosity and really your inspiration. I also want to start by acknowledging my two co-authors and business partners, Susie Scanlon-Rabinowitz and Gary Berger. If you'd wave so that everybody in live can see you. I knew you were wonderful people to partner with, but I didn't know what dear friends you would become of mine. So I'm so grateful for you and your collaboration, and I look forward to much more with both of you. I just can't help but also acknowledge my family in the room, my husband, Gordon, my son, my oldest son of 3, Oliver, my parents, Stanley and Sylvia Epstein, and my oldest and dearest friends, Claudia Troop and Rachel Summers. And when we will get to this subject of bliss very soon, and I have to say in my own life, it is my family and my friends who bring me that. And so for all of you, I'm grateful and really appreciate your support. And we can't get into tears when we're talking about bliss, so I'm going to turn it back over to you. Oh, one more important thing. I am going to, of course, thank Kirkland at the end, but I would be remiss not now just acknowledging my dear friend and colleague, Linda Myers. And I'm just sorry for the people on the webcast who can't see her shoes, because they're so fantastic. In addition for her inspiration and her thoughtful leadership, she's also, top notch in terms of style. So thank you, Linda. We'll get back to thanking you and your colleagues at the end.
So that's no problem. We can talk about shoes and bliss with no difficulty whatsoever. Indeed, since you mentioned it, I have to say I looked at Linda's shoes and I thought, we have come such a long way from dress for success with the floppy bows and the sensible pumps. And it's a good thing. That is a very good thing. So Linda stole my opening question, but I do have to ask you, this is what everyone says. They say bliss, law, come on. How are you putting those two together? So I want to start just by asking you, how did you and your co-authors come up with the title, with Bliss Law in general, and then the title of this book?
Sure, and it is a bit of a long story. I'm going to try to really be abbreviated about it. But nearly 20 years ago, I started really getting interested in the issues around work-life satisfaction, and particularly women's issues, when I started Flex Time Lawyers. And it's just been a prevailing concern of mine for years. Why is there so much dissatisfaction in the profession? And in writing my first book, Law and Reorder, I did a book tour and talked to lawyers around the country. And that was really the first time I realized this is not just a work-life issue. This is not just a women's issue. This is a problem with the legal model that has caused so much unhappiness, really, in the profession. But what struck me is it's not just unhappiness with how you feel as a practicing lawyer, but also there was so much visible dissatisfaction in the general counsel in how services were being delivered. And that's really how I got connected to Susie and Gary. Gary and I had summered at another law firm over 20 years ago together, and so we knew each other, and the two of them were working in a virtual law firm. And they contacted me in 2008 and said, our clients keep on asking to borrow our lawyers. We're dispatching our lawyers to all these places, and we need your help because we don't want to decline our clients because they'll go elsewhere, but at the same time, we need people to do our own legal work. So we started partnering where I would dispatch people from the Flex Time Lawyers Network to their virtual firm, and in 2011, the demand became so great that we started this evolution of what's called a secondment business into a company called Bliss Lawyers. And so when we decided to name the company Bliss Lawyers, which is the origin of the name of the book, we really thought really critically about this and thought, what is going to make a higher performing profession and also lawyers who really derive satisfaction, and it has to be happiness at the core. And so when we named the company Bliss Lawyers, that was critical to it, but in naming the book, it was the same thinking. And people sort of, say, oh, this is tongue-in-cheek, but it really isn't, actually. And Gretchen Rubin, who's a happiness expert, writes the conclusion. She does the introduction to the conclusion of the book, and what she says is happiness is not a luxury. And employers who think that happiness is a luxury, they're mistaken, because the research is very strong in this area. The more happy people are, the more engaged they are, the more profitable they are to their employers, the more productive, and the more engaged they are and loyal to those organizations. And seeing you nodding, you know that's the case. And so while it is, of course, people are constantly getting, is this an oxymoron, the happy lawyers thing? It really is not. And I think we need to get back to how we make our lawyers happy and in turn, how they deliver client service in a more effective and productive way.
So I'm going to ask you to talk about those models, but I want to find out who all of us are first, which will be helpful for this conversation. How many people in the audience are in-house at the moment? How many with big firms or law firms generally? Everybody on this side, nobody in the center. Okay. All right. How many in law school? Do we have any students? And how many alternative legal models? Right, fair number already. So the center has already got the picture. All right, so with that sort of range, the basic argument of the book is it is possible to have happy lawyers and happy clients if you innovate. And then you talk about a number of different kinds of new models. And so I want to ask you to describe those and start with the actual new models, because there are ways to innovate within firms, which is a good thing since we're sitting here within a firm. And there, you can talk about that as well, but start with the new models. You just mentioned a secondment firm, which is not a term I think most people know. Coming out of the State Department, people are seconded all the time in the government, but not so much in law firms.
Sure, and I think how you frame the question is really critical. Innovation is going on both at the traditional law firm level as well as just new legal service providers that are evolving. And so I think it's really important to tackle both. But to your question really on the new legal models to start, a secondment is something actually the traditional law firms have been doing for years. And it's the notion of, let's say, a Kirkland lending out a lawyer to a trusted client for a temporary term, let's say, to help with that M&A deal. And that lawyer typically works on site of the client. And that has been going on for years. What has changed, and one of the new legal models out there is the one I mentioned, like with Bliss Lawyers, where it's an independent company that lends out a lawyer and on a temporary term to a client, to a law firm as well. And when that engagement ends, that lawyer comes back. And so the company is at no employment risk because they're not employing that person. What's also important is the historic notion of temporary attorneys were lawyers who were not so well credentialed, and they were ones who didn't have benefits, were not well compensated. What's changed is, certainly in the traditional law firm model, those secondees were well compensated. They were compensated by the law firm. But what's also changed is in the new legal models, these are highly compensated, highly trained, well-credentialed lawyers who work on these temporary engagements. They're W-2 employees of companies like Bliss. And yet the work goes away, that lawyer returns to Bliss or another company. So that's the notion of a secondment. It's a borrowed lawyer who's well-credentialed and brought in on a temporary term. There are other really interesting legal models that are out there. I mentioned this initial book tour I did on my first book. What I heard from GCs is an increasing frustration that they were often paying for the real estate of the lawyers that they were hiring. So virtual firms have become very popular, and that's a way to reduce the principal overhead of a firm, and we're going to get to how to do that.
Completely virtual?
Well, it's interesting. So my colleague's firm, it is a completely virtual model. Typically, overhead is a third of the cost of a law firm. So if you eliminate that, and then you're able to pass on that savings to your clients and also still be generous to your employees, that's a very successful model. Law firms that are traditional have tweaked that and done that in a really interesting way, which I'll come back to. But the virtual law firm model, it has been an enormous asset because it saves the clients and also, again, still compensates the lawyers very well.
And you can just rent conference rooms or whatever you need.
Right, and there are whole companies that are based on that, like a company like WeWork, where they just lend out space, they rent space to people on temporary bases. So you've got virtual and secondment firms. And then you have that whole industry around discovery and document review. It's more than $1 billion industry. You've got legal process outsourcing firms that are in India and China and Israel Israel and other places. So there's that going on, which is a lot of innovation. What's changed around that is...
So let me stop you. I get that outsourcing discovery could be bliss. That much. I don't believe discovery could be bliss.
Right. Yeah, no, it's a very important thing to highlight. But the interesting thing around innovation is initially when this was going on for LPO firms to do this outsourcing, it was thinking, okay, well, they're really cheap and it's much cheaper to do it in a place like India. But what's changed is also, okay, if these are companies that are principally focused on this, they're not only cheaper, they are more efficient, and they do a better job because this is all they do. And so the notion of heightened performance, in addition to more efficiency and decreased cost, is a really powerful model. So there's that going on. But then there's other really interesting innovators, like a company like Fastcase, for example, which is competing with a Lexis or Westlaw. And that's a company where you identify what legal support and what cases you'll find basically on the same algorithm as Google. So you can do a search and find, okay, what's the most relevant case that I want to support this brief or that kind of thing. So that kind of innovation. Another one I have a friend here who is with a company called Practical Law that's now owned by Thomson Reuters. But that is a brilliant new legal model where basically they looked at initially deal lawyers who were all creating the same forms and the same contracts to do that M&A deal. Instead, they had high-level attorneys draft these initial deal papers and contracts. And now companies and law firms like Kirkland can buy and subscribe to this service so that they can create more efficiencies for their clients and say, okay, I'm going to start at this deal that's already been drafted at a much higher level and create much more efficiency and cost savings. So those are just a sampling of
these lower cost models that are going upscale, right? I mean, you can go online and draft your will, right? I mean, that's been around for a while.
Right.
You could always get temps, but in both cases, you're actually going up the value chain.
That's exactly right, and it very much ties to the talent pool, and that's something I know we're going to get into. But part of more effective delivery of legal services is about better aligning the needs of clients with the delivery of legal services and matching the talent pool who's going to meet that need for clients. So that's an inextricable link that hasn't been as closely connected in years past.
So I want to then ask you about how innovation's happening within law firms. But I'm guessing that there are a certain number of people in the audience who are listening to you and thinking, wow, in first place, it's disaggregating the different elements of legal practice and outsourcing them and essentially, then reassembling streams of a service in different ways. And I'm guessing there are a fair number of people who think, well, that's fine. But, a place like Kirkland and Ellis doesn't need that. A big law firm doesn't need that. It's what needs to happen on the margins of the profession, but not at the core. So I wondered if you talk about that a lot, at least when in the audiences I talk to in DC often, or I often get this, all that tech stuff, that's not really going to change the core of what we do. And certainly academia tends to think that too.
Right. I think that's a critical question because I think there is a lot of cynicism around the innovation. And they'll say, you know what? Things seem to be pretty much functioning as normal. I think there's a number of reasons why people think that's the case and why I think we all need to be much more thoughtful about change. One is we want to be ahead of the change. We don't want to be sitting pretty and then all of a sudden be saddled with real challenges in our businesses that we could have thoughtfully prepared for and we haven't. So that's just a starter. But I think the cynicism around this change, for starters, is how we as lawyers are trained. And this is a point that actually somebody else made, which I have just kept with me because I think it's really thoughtful. We're trained as lawyers to look backwards at precedent and to think, okay, well, we're going to decide the future based on how it was decided before. Even though there are a lot of smart lawyers out there, in terms of creativity and innovation, when you're trained to look backwards, it's hard to really reframe the brain to say, okay, I'm going to be an innovator and think ahead. So that's just a premise in training that we need to work on in law school. Beyond that, I think that what's changed is that a lot of the pressure is on the firms that are below that first tier. So the global elite firms that are really doing the bet the company work, that is shrinking. So if you're a firm like Kirkland and you're in that global elite, your work is actually not price sensitive a lot, because if your company is on the line, you want to hire a firm like Kirkland and say, okay, I need that name on the papers, and I'm willing to pay whatever it takes to do that. What's changed is that circle of firms is shrinking, and below that tier, a lot of those firms are really hurting, and you open the papers or read online on a daily basis which ones are shifting and crumbling and merging and things like that. So there's a lot of discussion around whether that next tier lower of larger firms is going to become almost subcontractors of work. And that's where a lot of the changes is really going to be impacted. I think there are other things that are going on that are making us cynical about whether change is really real. And I think what has happened with a lot of the large firms is they've tried to maintain the partner income, and they've done that by cutting the costs. What a lot of those costs are actually associate heads. And so the partners are not the ones who are necessarily feeling the economic impact so much. And so because of that, it's not as readily apparent that change needs to happen. And this is a really challenging question, because how do you ask management, who are the ones who are really thriving on the model the most, to look inward and say, we need to think about this? But if you look at the shrinking numbers of incoming associate classes, you see there's an economic impact here. It's just there's a rejiggering that's going on, so we're not as relying as heavily on this influx of large associate classes. So that's a lot of what's behind it as well. There's more on that, but yes.
So I want to ask you then how those firms are innovating, but just to say, this is very similar to what's happened, of course, in media, where only the very top, the New York Times is still there, the Wall Street Journal is still there. I understand, but it's about what is about to happen to American higher education. So I taught at Princeton and Harvard. Princeton and Harvard will still be there. So will Yale.
Thank you.
But the tier just below, where it's very high fixed costs. We're in the information business. The cost of information is now almost nothing. And so the question, and you've got lots and lots and lots of new models out there. So we're all in, I think, for lots of disruption, and even those institutions that will make it through will look very different. So maybe talk a little bit about what innovations established law firms are making.
Absolutely, and just apropos of your remarks, Anne-Marie, I think this is endemic across industry, and I think that was frankly the reason why I so much wanted you to be a part of this book. Is I really see you somebody who's talking about these industry issues, all over industry, and looking at institutional and individual change in these different industries, whereas of course this book is really focused on law. So in response to your question, where I really see innovation happening in law, we're just bringing up the mic. That's there.
Right.
Yeah.
Go ahead, keep going.
I see really innovation happening in traditional law firms in a number of respects. One, and in some respects, the most compelling way where I see innovation really having to happen is in terms of the billable hour. You've got some of the large firms generating, maybe 30% of their revenue through alternative fee structures. And so the idea of using alternative fee arrangements as opposed to principally the billable hour is a way that innovation has to happen. And we're going to get more into that conversation, I know. But seriously, that is, in my mind, the most critical way that firms need to innovate, and they are innovating. In other ways of interest, the talent pool. There's opportunity to innovate there, and it is going on. Interestingly, that area of innovation is happening more in the UK than in the US. There's a firm, BLP, a large firm in the UK, that years ago developed an alternative talent pool, and they called it Lawyers on Demand, LOD. And the idea was they felt that they were losing these different parts of the representation of their clients, that they used to handle a whole representation, and now their clients would go to them for the high-level work, but, when there was other work to be done, they would go elsewhere. They didn't want to lose that business anymore. So they created this alternative talent pool, LOD, and they were able to retain the work from a lot of these high-level clients as well as get new clients because they were doing a different type of work that was with temporary attorneys and that sort of thing. And so that was separately branded, so they were able to protect their fees and their sort of other stature. But But that notion of thinking differently about the talent pool, and by the way, after BLP did it, then Freshfields did, Allen Novery, numerous other firms in the UK are innovating around their talent pool. I actually have some skepticism about whether really law firms want to get into the talent business in that respect and sourcing out talent. And I think that the trends in the industry are around outsourcing. So, and that's a self-interested point, so I'm just disclosing that. But still, I think that there's really interesting innovation along those lines. There's also innovation about just using the internal talent pool differently. I know we're going to come back to this, but using non-lawyer professionals more because they're less expensive and more responsive to client demands, again, is really important. Using temporary talent internally is another critical thing. The other area of innovation, two other things I just want to touch on. One is about re-engineering space. So we talked before about the virtual firm. There are variations of that large law firms are doing that make a lot of sense. And what's important in any innovation is it can't entirely be cost-driven. There has to be an alignment with some other benefit. And the re-engineering of space is a great example of that. So some of the large law firms are creating more communal spaces, which saves in terms of real estate, but it also helps in terms of facilitating more of a feeling of teamwork and things like that. They call them hospitality industry touches. So you'll go into a Kirkland, for example, and you walk in, you're like, wait, am I at a high-level hotel? Am I at a law firm? Where am I? And it brings about more community. It's something actually Gen Y is really pushing in a very effective way. It's also happening in sort of eating spaces of law firms, again, for the same reason. Also, there's just a different use of light, and by using like walled interiors and a lot more windows and things like that, again, you can get smarter about real estate costs and be able to create more of a sort of jubilant, blissful attitude internally and get people engaged more. So that kind of re-engineering of space is really important. The last thing I'll just mention is re-engineering relating to information. Clients are really struggling with just an overwhelming amount of data, and they really want help from their law firms about how to categorize information more effectively. So I've seen some really interesting innovation around e-data practices that law firms are cultivating. Again, thinking more critically about how to be directly responsive to the pain points for clients and being able to better align services to meet that.
Fascinating. So, and I'm looking around at this lovely communal space as you're talking. It is, as New America has been looking for new space in D.C., it's been very interesting. I'd say half the places we looked at when the broker took us on tours were places that law firms were vacating. They were downsizing. Because it's just too expensive. And we're coming in, taking smaller space, using a combination of open space. But, law, like being in the think tank business, we need our own space to think and write. So the full tech model, it doesn't work. But those are interesting ideas. And the whole point about being part of the on-demand economy, that's also a much, much bigger shift, right? What we're talking about here is essentially the Uber or the TaskRabbit of law. Mm-hmm. And that's happening with doctors, it's happening with bankers, it's happening with executives. There's an on-demand company in LA that lends out an executives to get projects done. And we're going to see that more and more from the point of view of those of us who need to balance really high-level work with other things in our lives. That's all good. But it, again, is going to disrupt the industry. So let's talk about value, because there are a couple really big ideas in this book that I love, and one is sort of how you measure value, which I want to ask you about, and another is the Olympic rings of talent, which, as you'll hear, I think is just fabulous. But one of the things I write about on work-family balance is, the billable hour system is crazy if you're thinking about, quality over quantity, right? A system that pays you to put in more hours is not a good system. It's not a good system for you if you want to be efficient, and it's not a good system for the client. And where we're moving in lots of other areas is stop with the amount of time and start with the quality of the output. Let's measure results. Let's tell people I need this product by this time of this quality. And if they can get it done in half the time of someone else, terrific. They can go home. They've used their time well. The person who's here till midnight, my response is, you're not using your time very well and you're wasting the client's time. Now that was not the attitude in big law firms when I was in big law firms in the mid 80s. But you talk a lot about how do we measure value. So
yeah, I think it's a really thorny, challenging question. Something that I like to refer to instead of the billable hour as a measure is something called the quality measure. And the idea is there's three components to measure value as opposed to the billable hour, as opposed to hours logged. They're threefold. One is quality of work. So bottom line is you need to get high quality work. And if we're going to compromise the quality of work, then that is not going to be the answer. Second is efficiency, as you mentioned. So you can be great and produce the most amazing work. But let's say it's a brief that's due on Friday, and, to come up with that brilliant brief, it's going to take you 3 weeks rather than have it due Friday. Well, then that's not going to help. So it has to be quality of work balanced with efficiency. But the third is results achieved. We have to be able to not only do great work and be efficient, but, this is not just, working in a vacuum. We need to get the deliverable. We need to get the results. So to me, the interplay is of those three things, and the law firm that figures out how to measure that and really how to and reward it, and not just how to measure and reward it, but how to build clients based on it, and how to also reward internal talent and then promote talent accordingly. That, to me, is really the trick here, and that's what has to be done. And I think what really is pushing up against this is this notion of risk, and nobody wants to make that wrong prediction. And so we talk, one of the chapters of the book is on
that wrong prediction about
what, how long it's going to take, because there is some factor of efficiency, of course. And so if you predict that it's going to take a certain amount of time and it takes so much more, then, you're incurring more risk as a law firm than you may want to do. And so that balance really relates very closely to another chapter of the book, another discussion we have around predictability and trust. If there's more trust between the client and the law firm in the relationship, then you can work through that much more, readily, to be able to say, okay, we thought it was going to be this. We don't want, you to be saddled with, more of a, hit on this than you should. So there has to be more of that. But the idea of having that balance in place of quality of work, efficiency, and results achieved, that to me is really critical. But I just want to touch on the billable hour. There is some work-life opportunity there that I think is really missed by law firms. And over a decade ago, I did a program.
Leaning forward at this point.
I did a program over a decade ago called the Billable Hour Bully. And I thought, everybody was going to come in and just be like, it's the worst. And it was a group of a lot of lawyers who worked flexible and reduced hours. And they said, actually, it can be your friend, because the firm generates the same revenue wherever you bill. And so why aren't we capitalizing on that? So there's one issue around work life where it's just the sheer number of hours are too great. But a lot of work life satisfaction is around flexibility in where you work. And so if firms were more comfortable giving that latitude and realizing there's no revenue impact when you give lawyers more control in the way in which they work, again, getting to that happiness factor, it can be a dramatic difference. And I think firms are missing that opportunity to really capitalize on it while the billable hour is alive and well.
So it's interesting. It's like I remember giving a speech to about 1,000 women in sales out in LA, and their reaction was very similar. It was, in sales, as long as you make your numbers, that's all that matters. And so many of them found it much easier to balance what their family responsibilities with their work responsibilities, because there was a very clear metric, and It wasn't about FaceTime. It was about the numbers, which makes it easier. So, okay, so now let's talk about this Olympic rings of value and how you are Olympic rings of talent, and how you then think about the talent pool in addition to measuring them in a new way.
Sure, and so the historic notion of a law firm is you've got that brass ring, that you're seeking the brass ring to become an equity partner. And something that's really challenged me in my years in consulting is that there's a fallacy there, because most of the people entering law firms are not actually seeking that brass ring. And not only that, most of them they don't have the stuff to get it. And so why isn't there more transparency, and why isn't there more valued paths to success at a law firm? In other words, we don't want to have a talent pool that the majority are failing because they're not getting the brass ring. Instead, why don't we embrace the fact that there are multiple paths that people are seeking, and why don't we give recognition and support and promotion opportunities within each of those paths. It was funny, recently I was at a conference and there was a representative of Twitter on the panel, and one of the HR people, and she said, every year we sit down with our employees and go over what are their hopes and dreams and aspirations. And she was relaying a conversation with one of their junior people who said, I'm really loving Twitter. I hope to be here for next 18 months or so, and then I want to go and do something else. And in fact, the person was completely candid, and I was thinking, I wish that conversation could happen in a law firm, because, by the way, that candor actually would benefit the law firm, because wouldn't it be better for the law firm to know, okay, this is somebody who really wants to, pay back their student loans for these 18 months, and they're a great worker, we want to they may be a client one day. Wouldn't it be better to have that heads up of what their objectives were and try to support them so they become a loyal client or something else to the firm? So the idea of candor and transparency in the career path process, to me, is critical. And then this notion of Olympic rings is, to me, a very powerful image. So the idea is, rather than just the brass ring, you'd have 5 different paths at law firms. And just like the Olympic teams, you would be valued for just having made the cut, making the team. There's gold, silver, and bronze. The idea is you could have promotion paths within these 5 different paths.
So what are the rings?
So
one is partner.
So in terms of the rings, I wanted to really rely on terms that law firms are comfortable with so that they could really ideally imagine themselves doing this. So they're all familiar terms. They are equity partner, non-equity partner, senior counsel, and senior staff attorney. So the idea is, and just to take you through one of them, a staff attorney is somebody who's not on partnership track. So if that person is valued, there's various levels of promotion within that staff attorney path. The idea is, let's say you're a staff attorney because you have significant family responsibilities at home, you have 2 ailing parents, and you have to, for a period of time, be on that path. The idea is the Olympic ring is a ring. It's not a ladder. So the idea is there's fluidity there. So if you are on that path and then your parents thankfully improve their health, if you have the skills to otherwise be on the partnership track at a Kirkland, you would be able to get back into that. That's the reason why those Olympic rings are interlocking. These paths are not obsolete. And it's also not a path as you're on or you're off, because maybe you're a woman who wants to leave the profession for 2 years to care for some children, or maybe it's because you're a man who wants to do that. That circular ring allows you to come back into the circle as opposed to be on that track and be off forever. So that is a very different message, and I want to underscore, this is business driven. So this is not about accommodations. This is that clients are saying, we want to pay different rates for different types of services that law firms are delivering, and in turn, you can better align the talent who's delivering that service with the service that's actually being delivered. So it's being more thoughtful about paths that people are on, allowing there to be crossover in paths so that it's more forgiving. I mean, you look at the stats on women, for example, that 30% of women lawyers leave the profession independent of maternity leave. You're just saying goodbye to that whole classification of women because they have a nonlinear path. That's why we have to look at the circle. That's why it has to be interlocking. And by the way, this is not just a women's issue. We know that Gen Y is pushing this issue in a much more gender-neutral way, in a much more reason-neutral way, meaning not just about parenting. So when we talk about engaging a diverse workforce, this is about part of the way to do that is to move away from the linear model and understand, again, that's going to be in the employer's interest to do that.
So this is where I think, again, partly this is disaggregation, right? We look at disaggregating all the different services and the products that a law firm performs. Now you're disaggregating the different positions within the law firm at different stages. But the idea, it was completely up or out. And that just doesn't work. It hasn't worked for many women with family responsibilities. So women in some ways were the canaries in the coal mine. But what they were pushing up against is much broader than a working mother. It is an entire generation, as you pointed out, who, 2 years, 3 years, 4 years, that's a long time from a millennial point of view of how long you want to work. And I would advise you to read The Alliance. Reid Hoffman, the head of Twitter, published this book called The Alliance, which is all about how young people should work. And it's borrowed from the military's tours of duty. He describes all firms. He says it used to be the model that, you came into the firm or the company and you worked there forever and they took care of you. Well, that clearly disappeared. And we replaced that with complete contract work. I don't owe you anything and you don't owe me anything. That has serious drawbacks on both sides. So the alliance is, okay, I know you're not going to be here for that long. Your job, though, is to to do the best job you can for me. And my job is to teach you as much as I can so that you then can go on and get another job and you're still my alum, as you said, you're my client, you're part of my ecosystem, and then I get somebody back in. So that's an employment model that has nothing to do with law, but that this idea of having multiple ways within a law firm that you can succeed and that you can shift paths. So you can come back in if you've been a senior attorney or of counsel, your kids leave home or your situation changes otherwise. Why can't you try to make partner at 50? Like, what law is there that you shouldn't be able to try to do that? You've got a good 20 years left of productive work, certainly 15, and you should be able to decide where that is. So I love this image because I think it captures something that's happening in much wider employment markets.
Right, and it comes back to this notion of happiness. Don't you want to inspire all of your lawyers to perform at their maximum potential? Don't you want to create incentives in each of these 5 different rings for them to reach certain milestones? And I just want to quote from the foreword in the book that it's just a brilliant line you say that's just apropos of what we're talking about, Anne-Marie. You say, it is becoming increasingly clear to me that in law, as in other industries, women are not apart, but merely ahead. They are the canaries in the gold mine, signaling that the air is becoming increasingly unbreathable for everybody. And I loved when I was working on the edits of this book, the copy editor changed canaries in the gold mine to canaries in the coal mine. I'm like, no, that's her brilliance. We're talking about gold mine here. So, but it's very much that, women have been in the trenches and their challenges with respect to these issues are really our warning sign that there are bigger problems with the model again.
And more men are going to be taking advantage of these if one member of the partner, male or female, is in the job that has no flexibility, then the other member of the couple has to be what I call the lead parent. And that doesn't mean that person is not working. That means somebody is the lead parent, the person who's there, the person who's not on a plane, essentially. So let's move from there, and I want to talk about the flexibility and diversity and a couple of other things. But I want to ask you about flexibility because a large part of the Olympic rings is one kind of flexibility. It's flexibility in the arc of your career, but you also write a lot about flexibility more broadly. And I kind of want to ask you what's new. We've been talking about flexibility for a long time. And I actually argue that part of the problem is not flexibility, it's the stigma that attaches to that flexibility. But you've got some different twists on it. So talk about flexibility.
Sure. So one of the chapters of the book is on flexibility, and we have the general counsel of McKinsey as one of the thought leaders who contributed to the book, who does the opener on this chapter. And she said, we're not talking about flexibility as we know it historically, as an accommodation. This is about agility. This is about a changing market and who is going to be most agile in being responsive to it, both in terms, again, in managing the talent pool, but also in terms of being responsive to clients. So, one great example of it is Hurricane Katrina. After 9/11, companies and firms realized we have to be able to be prepared for some natural disaster or an unnatural disaster. And so firms and companies really got smarter about technology and so that when Katrina came, they were able to sort of operate without any hiccups and be able to jump in. So that's an example of flexibility and being smart about how to design work differently, anticipating really a business preparedness issue. But another thing that a number of clients who we interviewed for the book said in relation to flexibility is that's what they want from their outside counsel. They said, we want counsel that has not this infallible approach, but actually can make mid-course corrections, can be open to new information, can change the course. We had the GC of McKinsey who said that. We had the GC of the Citizens Financial Group who said that. We do an opening quote in the book that's on that same subject. That's a really powerful thing. So flexibility in more in terms of being agile, being able to change the way you address a problem based on new information, that's what we want. And clients will do it also in terms of wanting to expand and contract their talent force so that they can address the crisis at hand, and then when the work goes away, again, not have that talent pool who needs to be on hand to handle it. So it's flexibility on a multitude of levels.
So get ready to start asking questions. We're getting close. I'm going to turn it over to you. So we talked about flexibility, but also what about diversity? Because that's the other sort of buzzword that we've all been talking about in many different ways. And thinking about firms that are much more flexible, much more agile, many different kinds of work tracks. Where does diversity come in there?
Sure, and I think, again, what's important here is we're talking about changes in the model itself, and through that, there are a lot of interesting opportunities, and one is with respect to diversity, and I can give an example of what we found at Bliss Lawyers along these lines. When hiring lawyers, and this is across industry as well, there are really two principal biases that regularly exist. One is competency and one is commitment biases. So there's a skepticism, oh, this person's resume is not from the top tier law school that we normally recruit from. Maybe they're not as competent, or we have this woman who's left the profession for 2 years and now she's trying to come back. She may not really be committed. Does she still have kids at home? Does she have kids at all? They may be just some big distraction. So those biases are very inherent. And so what we found is that if you change up the model, there's an opportunity to have more diverse opportunities. And so we call it actually on-deck diversity. And the idea is if you have, and I'll give you an example, we have this investment banking client that asked to bring on a lawyer for a certain engagement. That lawyer was African American, is African American, and she was brought in on this engagement, and she was brought in through us rather than the typical hiring practices of this investment bank that often has a lot of these commitment and competency biases built in. What we found in the research, and this exists beyond our own research, is that when somebody has a bias, if they have a direct personal relationship with them, it overcomes it because you make that connection. And it's like, oh, we forgot about that sort of skepticism we had about you not being from the right law school, let's say. We put this lawyer in place, and she did just that. Through that personal connection, she was indispensable. The client ended up hiring that lawyer and now has increased their diversity at this investment bank and has this high-level woman who's African American who's thriving at this company. The idea is having diverse talent on deck and being able to circumvent some of the traditional hiring practices that may have these embedded biases. It creates an exciting opportunity. We've seen it manifested on a number of levels. And so the thought is not, oh, this is how we get diverse talent in place only by using new legal models. But it forces us to think that we need to change up infrastructure in order to increase performance of individuals. And we can't just think about the notion of leaning in, and I know we share this thought, that it's not just enough of that individual to do different things and learn different set of skills. It's looking at the model and the infrastructure itself and saying, how can we be smarter about redesigning it from a business benefit and then see that inherent benefit on a diversity level or some other level?
So that feeds perfectly into my last question. But I remember talking to you about a year ago, and you said when you second some of the people you second for from flex time lawyers, what you're really doing is it's an extended interview, right? That you are putting a lawyer into a say in-house for a year or on a project for a year, and often that then gives them the time to get to know that lawyer and to hire them, which is an interesting way of thinking about it.
It is. I mean, this notion of the extended interview, I think, is really compelling, and I think what it speaks to is that most performance by individuals is demonstrated by being in that environment. And there's a lot of great legal talent out there. And so we don't really have an issue around pedigree or whether people have the right credentials. We have an issue around fit. Yeah, like, is this somebody who can, play along with others? Are they part of the team? Are they engaged? Do they fit into the culture? And that notion of an extended interview is an opportunity to explore just that.
So last question. We're talking about different talent, how you engage talent. how talent is can work over the lifetime or over multiple periods in a career. How can we get a broader pool of talent in the first place? Because part of I could be having the same conversation or a very similar conversation if you were a law school dean. Right, we would be talking about all sorts of pressures. We would be talking about the ways in which the costs have gone up. The clients are not there, meaning it's harder for them to get jobs. There are all sorts of pressures in legal education as well as legal practice. And you've thought quite a bit about this. There's part of the book that actually says we may need a whole different model.
Right. I mean, I think, there's a whole subject about sort of changing up legal education, and that's kind of one area of it. But this notion of attracting a broader talent pool, I think a lot of this sort of fear in a lot of people entering law school today, and the numbers have gone down considerably. We had in 2013 40,000 law students matriculate across the country, and the numbers had not been that low since 1977 when there were, I think, 24 less law schools. So this is really a crisis. And I think a lot of it stems from the fact that when you graduate on average from a private law school institution, you graduate with $125,000 in debt. So it's definitely a select audience that you're able to attract to say, come enter this profession, particularly when they're, like we said before, those shrinking incoming associate classes. So you've got not only you're saddled with the debt, but the risk of whether you're going to get the deliverable in terms of the job. So I really think the answer in terms of training talent differently is an outsourcing model. And the way that it can be explained is you've got, let's say, take New York. You've got law firms across the country that are all training first and second year lawyers. A lot of it is a basic core competency skills that all law firm lawyers need to know. So they all have to learn, certain communication skills and writing and things like that on the one hand. And then they also have a specific expertise they're trying to learn. Let's say litigation. They're trying to learn how to take depositions and, take interrogatories and things like that. Why is every law firm incurring the cost of that basic level training? It's prohibitive. And as a result, these associates, they're shrinking the size because nobody can absorb the cost and responsibility of training these junior lawyers. Clients say we're no longer footing that bill, and so law firms in turn say we can't handle that on our own, so we're going to have to take less lawyers. I say let's outsource core competency to a separate body, and have first and second years at different law firms across, let's say, New York, be trained in those fundamental skills, and it would be a fraction of the cost for there to be a consortium of law firms paying for that junior level training. After you've gone in and done your series of training in those core competencies, you come back to a Kirkland and they say, okay, I'm glad you learned those fundamentals, now here's the Kirkland ways. But that tailoring is a fraction of the cost, and that to me is a real answer to this junior lawyer crisis in terms of training.
Barbary for discovery.
It's exactly right. And so we actually, in the book, we give two examples of outsourced training models that are already effective. One is Barbary. We've all said it's okay to entrust Barbary and its competitors to train graduating law students to pass the bar. We've also said...
Because law schools certainly don't.
Right, exactly. You can say that as a former law professor. NITA, National Institution of Trial Advocacy, they do outsourced trial training. Why can't we do this at the core competency level and then in turn entice more people to go to law school again and also attract different types of law students who we want to enter the profession?
All right. So I'm going to turn it over to all of you. Please just introduce yourself. Are there microphones? We probably don't need them. Oh, yes, there is a microphone. So wait for the microphone, introduce yourself, and just make sure it is a question. It can be a comment if it's a short comment. Yes, there on the...
And just saying your name and your affiliation would be great.
Sure. I'm David Shofi. I'm an intellectual property attorney, or most recently working in-house for a company in Connecticut. I'm interested in understanding, and by the way, it was a wonderful talk. Both of you really covered the subject well. You didn't mention anything about the issues of privilege and specific legal responsibilities. Are there any complications with what you're proposing in terms of that? And could you just expand a little bit about that?
Yeah, so it's interesting. That issue around privilege and confidentiality, things like that, have come up in terms of redesign of space. So unlike, let's say, certain industries where you can, let's say, have open space, it would be, there are certain constraints that a law firm would be under in terms of having protected areas. So that's one thing that's really a factor that has to be considered when you talk about innovating, let's say, in the redesign of space. The other area where I really see it coming up is when you think about traditional law firms competing with new model firms. One of the luxuries of many of these new models is they're not law firms. They're not constrained by the ethical rules that law firms are constrained by. So, for example, at a secondment firm, if you're not seconding from a law firm, but if you're just a secondment firm like a Bliss Lawyers, for example, you can have different lawyers working for different clients that compete with each other because the conflicts of these different lawyers are not imputed to each other. So it's enabling you to compete in a much different way than a law firm that has those ethical constraints. So those factors have to be part of this analysis of change on every level. And really, when you think about creating change around an infrastructure, you have to think not just, again, about the individual and what they could personally achieve, but within the model that they are performing within, whether it's legal and lawful and whether it's going to be respectful and providing the best service to clients. So those are really important considerations. I'm not an expert on confidentiality or privilege. Thankfully, I stopped practicing law nearly 20 years ago. So, but those are really critical factors.
So it reminds me of non-bank banks. I remember back when I did banking law in the early 80s where it looks like a law firm, but it's not a law firm. It's subject to different rules. Sooner or later, there'll be rules regulating those too. Other questions? Yes, here in the center.
Hi, I think I can.
Here comes yours.
Actually, for the webcast, we need to hear it on the mic. That's why. So,
Hi, I'm Deneen Bullard, and I work, I guess we can say where we work. I don't know. Morgan Stanley. You talk about the secondment lawyer and all of these models, but you also hear in the, in the general discussion of employment in the U.S. that people lose benefits. They find it hard to, get consistent pay. There's a lot that they have to do then finding, health care and that sort of thing themselves. So how do you deal with that at your firm, or how do you see that changing? I mean, maybe the Affordable Care Act helps in one area, but we know there are issues there. So I'm curious about that.
yeah, so actually under the new secondment firms, they provide W-2 employees with 401k, insurance, benefits, everything. And so to attract a different level of talent, you have to be able to provide a generous, robust package, which is what we do and which our competitors do now. So it's a different focus in that way. And if you're doing lower level work, unfortunately, those lawyers often aren't getting the same benefits and all of the accoutrements of a good job with as a W-2 employee. But that's how we've addressed it. We've said, we need to, if we want to do the work we want to do, we've got to attract the lawyers. And again, we've been able to do it because our company's actually virtual, so we've been able to eliminate that 1/3 overhead cost and be able to be generous with our employees and charge our clients less. But for those who are working on a traditional model and don't have the way to use the virtual model as a way to shortcut and save and be able to be generous in turn, it's more challenging for them.
I'll just add that this is, again, when you look at the trends in the on-demand economy as a whole, what you're starting to see are the creation of platforms that are really like the old guilds. There's Tom Malone, who's a professor at MIT, wrote a book called The Future of Work in 2004. Yeah. And he talked about the Screen Actors Guild. So the Screen Actors Guild includes everybody who works on a movie. They're all freelancers, right? You assemble them differently for whatever movie, but because they're members of SAG, they then get their benefits because they have that platform negotiates the benefits. And you are going to see that if you think of Elance or Odesk or these various platforms for different kinds of freelancers at high professional levels. They're going to effectively make benefits portable by separating them from the actual job.
It's a great point, yes. You just have the mic.
In Brooklyn, in New York.
Here comes the mic.
Yeah.
There is a company that was started in New York, and I think it's called the Freelancers Union, and it's that very idea.
Exactly.
Right. I think one of the issues also going on is that particularly in 2008 when the market became that much more volatile, I think so many people who were in traditional jobs realized there was so much instability in those jobs, and so there became a greater appetite to say, I'm going to try another way to work because I don't have the same security I thought I had anyway. I think you're touching on, though, a really important issue, which is the future in a lot of these industries is about less certainty overall. And that is, it's just seeing it as not just, a new model may have that. It's seeing that, the workplace in general has just less certainty than ever before, and you have to be your own entrepreneur and make things happen and be much more marketable in order to maximize your opportunities as they may change.
All right, there on the aisle in black. Hang on to the coming your way. Yes,
over here.
Right there on
Yeah.
the
Hi, my name is Alexis Lamb. I'm a recovering attorney, so to speak. The question I have is, you spoke quite, eloquently and very excitedly, and I'm excited about this too, reasons and ways in which the legal industry can kind of innovate and change and morph and kind of be disrupted into something kind of new, sort of like how the media industry morphed and changed, and how maybe tech is kind of disrupting everything, and engineering with Elon Musk and everything. And you're talking about industries that attract people who tend to kind of favor the entrepreneurial, the different, the disruptive. And then you talk about attorneys who kind of favor the tried and true and looking backward to precedent to determine what to do in the future, as opposed to tossing it aside and forgetting what stare decisis means. How much do you think of this, I don't want to say inability to find bliss, results from not necessarily the structure of the legal profession, because there's many different industries that have started the way the legal profession does, but have found it fairly, I don't want to say easy, but less of an identity crisis to innovate? And how much is it because of the people that are attracted, the personalities that are attracted to the type of profession that cares a lot about prestige and of, nice, steady salary, and not so much the entrepreneurial, risk your shirt, but, they value stability. They don't necessarily value entrepreneurship and innovation. How do you sort of address something like that?
Good question.
It really is, and I think that that is very real about what types of people, who of us are attracted to law, and it is a specific type of personality. I think the other thing that I didn't mention before is also your role as a lawyer is generally, to anticipate problems. And so, you're sort of the Debbie Downer in the room. You're like, if you haven't seen that Saturday Night Live, you need to see it. It's really like saying, this is this problem. We've got to plan for this, that kind of thing. And this is an issue, obviously, particularly with in-house lawyers, is, you'll talk to a CEO who's like, we don't want a business obstructor. We want somebody to facilitate the business. So I think part of your role as a lawyer when you get in that job anyway is to anticipate problems. And so it's like, well, how is that an inspirational person? I think it's a really challenging thing. I think that the more public we can be about models of success and ways that lawyers are thriving, outside of sort of, kind of the humdrum of the way business has always been done, the better. I think people need to see success stories. It's interesting, Kirkland hosted an interview I did in June of Gretchen Rubin, this happiness expert I mentioned before, and there was a similar cynicism, Linda, right, about that topic. Like, she's bringing happiness to the firm. What are they doing, I think we need to be more out there, that is actually a reasonable aspiration and a legitimate one. And by the way, we're going to bring more value if we can deliver that. And so it's funny, I've been doing some talks on law school campuses with my co-authors. We spoke at Columbia. I'm speaking at Harvard next month. I'm doing a lot of setting up these talks at law schools. I think it has to start there. I think that, those are the people who are entering the profession. I think they need to have, that as their expectation. It's so funny that I got the invitation to the Harvard event, and it's just somebody doing a cartwheel. And I'm like, I'm thinking that's never been in a poster at Harvard Law School before. But like, we need to have more cartwheels. You know what I mean? So those are my thoughts on that.
There on the aisle there. And I'll come back this way, I promise you.
Hi, my name is Lawrence Wong. I'm with a litigation firm called McCormack & Maddy. I like the idea of Bliss lawyer, and I also think you consider it as a model of innovative way to deliver legal services. So can I put it like that? Bliss lawyer is a semi-virtual, high-end recruiting, staffing / secondment agency.
Sure, that has a real like marketing twist to that. Yeah.
Or what do you think is the most innovative part of Bliss Lawyer?
We basically combined two innovations. So we took the brilliance of Axiom, which was really the first secondment firm that took high caliber lawyers and sent them to companies and competed with traditional law firms in doing that. We took that, and then we took the brilliance of other people innovating on a virtual model, and we combined them. So we said, okay, yeah, let's put these lawyers, actually now they work at law firms as well as companies, but let's have our internal team work virtually. And so our lawyers typically work at the client site, but our internal team is working, in their bathrobes a lot. And so that really costs the client nothing. Terry cloth is pretty reasonable these days. So really it's the combination of those innovations, and the key is that every innovation has to build on the next to really stay ahead of the curve, is that we benefited from the wisdom of other people innovating. And I think that's, again, where traditional law firms need to be thinking. I think that's new models who need to be thinking. One of the opening chapters of the book is introduced by Bill Henderson, a really creative thinker on the future of the legal profession, who's a professor at Indiana University. And he says, in introducing the innovation chapter, some of these names you see on these pages are ones you're going to see for a long time. Some are going to be, morphed into something else. So understanding that the process is evolving and that you want to be thinking how to get ahead of the curve and really build on the other wisdom that other people have started is, in my mind, really the direction we all need to be going.
You have just gotten my definition of bliss, which is my bliss is being able to write in my bathrobe. Yesterday morning, because I commute now to Washington a couple days a week, but yesterday morning was my day at home, and the kids went off to school, and there I am, and I'm thinking, yes, here on the corner. It's coming to you,
Barbara. Yeah.
Thank you. I'm Barbara Harris with Practical Law, so thank you for the shout out. And by the way, your shoes are pretty fab too.
Thank you.
With all these models, I see great efficiencies for the client. I see great opportunities for senior lawyers having more flexibility. I still don't see the path for the graduating law student in any of these models. They all seem to be based on experienced lawyers. You're seconding to in-house. You're not sending a first-year associate. There's the talk about the concept of training graduating students collaboratively is great, but someone's got to pay for that. And when they're at a firm, at least the really top ones, you're still billing clients for when you're training them. And so the virtual law firms, again, most of those that I have seen being developed, they tout the fact that all their lawyers have 7 to 10 years of experience at a minimum. So where do you see the place for these graduating law students with so much debt to go?
Right. I think this notion of the outsourced training model, this consortium of law firms who are doing it, the thought is it's funded by all the law firms that are in that consortium, and it's done by them at a fraction of the cost because they're not all having their own, private training services. But the point you raise about how do you get these lawyers who are then able to work in all these different models, that is really the elephant in the room. And it's, the truth is that everybody has benefited from the large law firms who have absorbed that training cost. And with clients pushing back and saying, hey, we can no longer afford that, and we don't want all those junior lawyers in the room or on the phone or in the meeting. it's really putting pressure on it. So I think the answer is to really have a robust core competency training, and that will enable more people to sort of get in at the ground level and be able to have some experience. I mean, the other thing that I think is something that really should be entertained and pushed in terms of law schools, and there's like right now the ABA Commission dealing with legal education reform, is why don't we have something more similar to the medical model, where it's part of your law school training, perhaps the third year, where you're required to work on site in a real job, whether it's in a pro bono setting or in some other setting. But that practical skills training, which is really, something that law schools are not delivering, and most law professors, sorry, but they haven't practiced law, so they shouldn't be doing the practical skills training, right? So if you had a component like a medical internship, and I'm partly doing this for my father, the cardiologist in the room, who's just like, there's still time to go to medicine. I'm like, I'm not taking over your former practice. It's over, Dad. But so just for that reason alone, we've got to inject medicine into the conversation. That to me is the component that's missing, and the best example of how compelling that was in the downturn, when large firms had these incoming classes of associates and they couldn't keep them busy. And so part of what they did was they dispatched them to clients and to nonprofits, and it was a really good exercise in the value of that training. So I see the opportunity being more at that level, at a robust core competency level, having law schools have an externship required component, and perhaps doing what was done on an unofficial basis with law firms when they brought in these incoming classes, and perhaps doing that in some other way. But that is really important, because we can't have people performing as lawyers in these other models until they've had sufficient training.
And I'll just add there, as my former law professor self, the other disruption here is going to be in how legal education is delivered. So the head of New America's education policy program is Kevin Carey, and his new book's out today called The End of College, Inventing the University of Everywhere. And part of what he points out, in Virginia, where I grew up, you can still read law, right? In California, you can still read law. You do not have to go to a law school. So what's going to happen are there are going to be all these online ways of getting to the point that you can pass the bar. Well, but if you can pass the bar, you can pass the bar. And then you're going to have much less debt. And then you're going to have something much more like articling. Or many of my law students who were the happiest were the ones who were public defenders, or who went out and did pro bono law in various ways where they didn't have to get paid a lot. They were in court all the time. They learned the profession. Then and they've got about 10 years. The other thing is, since people are getting married and having kids later, they've got a long chunk of time where they can do that before they need to settle down to a steadier income. So you need to look at that in terms not just of what's happening with the people who come out of law schools now. You need to understand that those law schools are going to look unrecognizable in many ways.
And I'm glad you brought up the online piece, because one of the former practical law employees is now starting up a company where he's doing, you probably know this, junior lawyer training through an online component. I still think there needs to be on-site training, again, similar to the medical model, but that component of bringing online in is just a natural.
They're in the back, then I'll come back around inside.
Hi, I'm Allison Stein. I'm a media and entertainment lawyer at Jenner & Block and a close friend of Debbie's. And I am a happy
And
I am a happy law firm lawyer, so I'm generally optimistic, and this talk made me even more so. But the place where I'm really cynical, and Debbie and I have spoken about this, is the billable hour. I feel like this is the 5th year I've been at talks, and you and I have chatted over coffee and drinks about the billable hour and how it's a problem, but
you're making us sound really boring. Hopefully we talked about some other things
too.
Okay.
But I don't see any change. And as I get more senior and closer to partnership, I can tell that it's even affecting my thinking. So I'll finish a week and put in my time and be like, yes, I have so much time. Or I get complimented for how hard I've worked and I'm proud of myself. And then I feel kind of sick about it, that, why is that a great thing? And I just feel kind of hopeless about, change in that area. So if you could maybe make me feel a little more hopeful, or tell me that you've actually seen, because the big firms we work with really do still use the billable hour model.
Yeah, and I think that is principally the case, and you're clearly not the minority in that. It's interesting. The billable hour really evolved in the 1950s when lawyers were losing economic ground to doctors, they felt. So they thought this was going to be a way that they could really anchor their revenue generation. And the challenge, of course, around the billable hour is that you've got the 24-hour day as a fixed variable, so that's the maximum. And then the only other way to increase revenue besides increasing hours is increase rates. And even though there was a recent article about like how the 1,000+ hour lawyer who charges over $1,000 an hour is becoming more commonplace, it's still hair-raising, to so many people that that this is actually going on there. And interestingly, just as an aside, as a consultant in the industry for nearly 20 years, I can count on one hand the number of times that law firms have asked me to bill by the hour. They're like, it's got to be a project, It's like, we're not going to pay you for those hours. So it is kind of ironic. I think the issue is that, and this comes back to this idea of like, oh, well, we have some cynicism here because things are pretty much the same, is that as a law firm, and I really think law firms need to be thinking more about this, don't you want to be making your clients happy? And don't you want your clients not to be, sort of shocked by these bills? These are your clients. And so to be ahead of these issues and be ahead of the curve and be able to say, we're talking about more creative solutions, I think those are the law firms that are really going to earn a lot of points. I think one of the things, that is more negative along these lines is it's often the client who ends up defaulting to the billable hour. And that's part of what the sluggishness has been here, is from a client's seat, it's so easy for them to compare services when it's a billable hour. It's the devil they know, but it's also just, it's comparing the apples that they can easily compare. And so when we look at why there hasn't been more change on this, it's not just the law firm that is really preventing that. So I think that, the truth is that hours logged has been a very easy measure that is predictable from at least the law firm standpoint. And I think until clients start really pushing back and not just saying they're pushing back, but really pushing back and asking for that creativity, I don't think enough of change is really going to happen along those lines. I think it's a mix, and I think the firms that do get ahead of it are the ones that are really ultimately going to get the recognition. I do think it takes a Kirkland or a very big name firm to really be public about that change. And so far, all the firms that have put themselves out there and marketed themselves as solely alternative fee type of firms have been the smaller ones. So until we get more public, large firm out there, I think that it's going to be stalled. And this is a profession, by the way, very much a copycat profession. So if we've got one major anchor who's out there and saying, we figured out a way to do this better, we've got the value measure and we've figured out how to do it better, that'll really speed things along.
Okay, last question, one quick question here, quick answer, and I'm going to turn it to Debbie for some final words. And apologies to those of you who did not get a chance to ask questions. This whole section was silent, so I thought.
Is there a concern in the new models?
Just introduce yourself.
My name's Deborah Sherman. I've known Debbie for a long time, since our years at Yale. Is there a concern in the new models that effectively turn brilliant minds into commodities? It seems that a lot of the progress, as it were, is articulating what people are best at and how to achieve some of the training in more efficient ways. You expressed that there was effectively a Google algorithm that enables attorneys to articulate which precedents are most suited to their current case. Right. Now, that to me seems terrific in terms of time savings, but it also seems to negate the value of the extreme resource of data that are in the brilliant legal minds that are able to parse all the predecessing history that goes into making law. And is there some concern that when you value somebody as simply a service point, not the Bliss model, but the more typical temporary model, and not as the junior lawyers, but what do we do when we just go out of law school? Someone has to train them. Is there going to be a lack of necessity, just like all technology seems to ultimately mean that fewer people are needed?
Right. And I think, Deborah, I think your question is a really important one. It's valuable, actually, for somebody who's not in the legal industry to sort of look in and make that assessment. One of the big trends that's going on is commoditization of work. This is happening across industry. And so it's taking a lot of work that used to be done by individual lawyers and other professionals, and it's being commoditized through technology and systematized. And in some ways, it's actually relieving lawyers of doing a lot of the mundane, because it's saying, okay, this can be automated here. Let's now see what else is left from this disaggregated work to be able to be done in a really thoughtful way. It's saying, bring efficiency to the lower level stuff, and let's get the people who can think about this stuff in a critical way really start doing that. So there's more to that, of course, but that's just a little tidbit.
I'll say one word on that and then turn it to Debbie to have the last word, which is one of the other things we're seeing with millennials is a shift in the balance between money and meaning, right? That they want money. We all need to earn an income, but they're willing to take less money for more meaning. And at the same time, what I see with law is when I came out of college and went to law school, that was still, the era of Brown v. Board, right? You wanted to solve the country's problems. You thought about law as the way to do it. You thought about social justice. You might have been going to work for a large firm rather than a civil rights coalition, but you still felt like law was the way you achieved justice. I now see my students going in for social enterprise, not social justice. They're going to business school, and they're planning to use their business school skills to change the world. I still believe that law has a very powerful role to play, and I do think we have to recover that for law to really give people bliss. The happiest lawyers I know are the people who believe either they are solving important problems for clients and making businesses go that are productive, important businesses, or that they are achieving a measure of justice. And I do think we watched law be turned into a business, but that was within my lifetime. That can change again. And when it does, with all these different models, we'll also find ways for lawyers to feel like they are contributing in their way to what is ultimately absolutely essential to our society, which is that we live under the rule of law. And as somebody who studies foreign policy, that's not a given. So end of my speech, and I will turn it to Debbie for final words.
Yes, and I just piggybacking on that, I want to share a brief story just as my final party message. And in honor of my family who's here, I will share a story about our youngest son, Theo, who was in 5th grade at the time. And my husband coaches basketball, and then I have 3 sons who are basketball obsessed, so we are a basketball family. And Theo and Oliver played for Kobe Bryant's former coach and was on the state championship basketball team. And so my middle son was coming up and deciding, is he going to go to Oliver's high school or this other public high school that he could choose from? And Spence said, you know what, I'm going to this other high school. It's 15 minutes away and really a hassle for a working mom. I was quite upset about this. So at the time when Spence made this decision, I said to Theo, who's in 5th grade, what are you going to do? Do you know yet which high school you're going to go to? You're going to go to Kobe's former high school with Oliver, or are you going to go to Spence's high school, which is like hours away? So he said, I'm definitely going to go to Oliver's high school. I'm going to Kobe's former high school. I want to go to Lower Merion. And I said, well, how do you know in 5th grade that you're going to do that? And he said, well, if I want to get recruited for the NBA and I want to get scouted, I've got to be at Lower Merion. So Theo was 4'8" at the time, and he is now 5'6" in 8th grade. But I thought that moment when Theo said that, and looking at him as his 4'8" self, I thought that is a message we need to take to the legal profession. He's thinking big. He's not thinking these professional players are, 2 feet and 3 feet taller than me. He's thinking, I want to get recruited for the NBA, and I'm going to play for Kobe's former coach. We need to think big here. There's a lot of complications to these discussions. You've raised the issue around privilege and there's confidentiality issues. These are not little things that need to be worked out, but we need to think creatively, innovatively. We need to think about how to do work differently in a way that makes for happy clients, makes for happy lawyers, makes for happy law firms and other legal service providers, and really is outside of the scope of what we formerly contemplated. So with that, I want to thank you so much for listening, everybody. I want to thank Anne Marie. You are such an inspiration to me, and you are so tremendously generous. So I can't thank you enough for doing this and for contributing the book as you already have. So please help me thank Anne Marie. And I also want to thank Kirkland. They have been tremendous in hosting not just this event, but 2 other recent events, and just have been colleagues of mine for years. So Linda, with your leadership, I'm eternally grateful. And also to Rena Alvarez, to Beth Wiener, Jennifer Morgan, Rajinder Bassi, Aya O'Connor, Al Porteous, Patty Mesnich, Maria Black, Kate Slasted, Audra Simmel, Natalie Conkle, Kim Matthews, and Andrew Johnson. I also would be remiss not to acknowledge my assistant, Renee Newell, who you've all been in touch with, who's really incredible. And I hope to see you on May 20th at our next event at Clifford a Chance, where we'll talk about women in rainmaking. And until then, really thank you all so much, and let's continue to the conversation, and thank you for coming. Can we get one picture? Sure. I love